start. So welcome to our webinar on returning to the office. Thanks very much to Hayes for organising this session. We're delighted to participate. It's always really nice to work with the Hayes team. We've done a little bit of our housekeeping already. You know about the chat function and to remember to mute yourselves. So we've run similar sessions to this over the last couple of months, and every time is slightly different because the rules and the guidance changes so often, and also the public and maybe even your own employees' approaches and attitudes are changing as well. The last time we did such a session, we were all looking to the 21st of June as being the date that the restrictions were all going to be lifted, everything was going to change, and they came and went, and everything is pretty much as it is. And so it's a good example of how this pandemic kind of plays out quite often, because you can plan ahead so much, but there needs to always be a little bit of that flex and ability to adjust. So it's challenging. It's challenging to manage your workforce and to run a business during this time. But hopefully today's session will help you at least to look ahead a little bit about the things that you can do, the options that you have, and some examples that we've come across as well. So we're going to look at 5 different elements during this session. Return to the office, we'll discuss the current position as it is, testing and looking at vaccination, what can you require as an employer, what can you expect. I'll talk a little bit about handling employees who don't want to come back to the office for various reasons. Then we'll look at flexible working requests and employment contracts and provisions, specifically for people who are working from home, whether that is currently or making that something of a permanent change. So David is in charge of slides, and I'll hand over to Charlotte to start us off.
Hello, yes, so as Lisa said, I'm Charlotte, I'm a senior associate in the employment team, and I'm just going to be talking through a little bit about returning to the office, testing and vaccination. First of all, just a recap really of what the current position is. Because we have a devolved administration, and as we've seen throughout the pandemic, Wales's approach is very slightly different to England. And for businesses like ours, where you're based in both countries, that can just add another headache to the whole return to office question. So in England, the Prime Minister announced this new 4-step plan to ease England's lockdown on the 22nd of February. This saw a roadmap out of lockdown with restrictions easing with a minimum of 5 weeks between each step. And a view on reopening businesses was expected by the 21st of June, but that's now been pushed back until the 19th of July. Until then, people must work from home if they can. In Wales, the situation is similar, although we're still operating on alert levels. So employers should take all reasonable steps to allow their staff to work from home. Where that's not possible, the government says people should go to work. We're now in alert level 1, and we've been there since early June, and so we must still work from home if we can, and that's going to be reviewed again on the 15th of July. So in summary, in both countries, you shouldn't be requiring any of your employees to return if they are able to work from home. Having said that, it's no longer a criminal offence to go to the office if your job can be done at home. And we are seeing more and more of people starting to creep in where employees are facing mental or physical health difficulties working from home, or they've got a particularly challenging home working environment. If you do require any advice about how to make your workplaces COVID secure, then please don't hesitate to get in touch with us. There are lots of considerations, particularly around carrying out suitable and sufficient risk assessments, looking at different workers, implementing reasonable measures, and we give a lot of advice around this, but we're not going to be covering that today, so please do get in touch if you need any advice on that. If we could just move on to the next slide, we're just going to cover some of the common questions that we get around testing. Again, the position differs slightly between England and Wales. In England, the government announced on the 5th of April that everyone will be able to take a free lateral flow device test twice a week if they wish to do so. Registered employers will also, they can continue to receive free workplace tests until the 19th of July. The deadline to register has now passed, and home testing kits are available to order for businesses who employ more than 10 people. In Wales, the lateral flow tests are primarily available for those who cannot work from home and secondary school pupils. Businesses can also access lateral flow tests for the workforce, and the government has a website mailbox so you can express interest in that. There are also plenty of third-party providers who are now helping to provide the tests or testing on site, so you could buy your own test if not eligible for government lateral flow tests. I should add, if you are using a provider to either carry out the testing or to provide a test, then you should make sure that you're carrying out full due diligence on those providers. So one of the first and most common questions we're receiving is whether you can make asymptomatic lateral flow workspace testing mandatory. The answer to this is possibly. For those of you who know us, often in employment law there isn't a black and white answer. So possibly you can, yes. Temperature checking or medical testing is not on the list of steps employers should necessarily be taking in the government guidance, but that doesn't prevent you from implementing a testing programme if you consider it to be both necessary and proportionate. It is also a step that is being encouraged by the government alongside other measures. Mandatory testing is certainly seen as less legal risk than mandatory vaccines, which I'll come on to discuss shortly. So when considering if testing is proportionate, you need to balance it against the business need and balance that against the fact that the test is an invasive and comfortable process, which doesn't always identify positive cases, as we'll all be aware of from the news. I should add as well that it also doesn't mean that you can relax any other control measures in place. When considering mandatory testing, there are two main legal risks to consider. The first is unfair dismissal and possible unfair dismissal cases where employees have more than 2 years service. The key question to consider really is, if you implement mandatory testing, what are you going to do if the employee doesn't agree to take a test? Would you be willing to discipline them, and would you be willing to dismiss them? If you are going down that sort of process and it truly you will move with the out is fair and reasonable. This hasn't been tested totally, and something else to consider is the tests aren't infallible, and they're not accurate as the PCR tests, and this will go towards the question of reasonableness. The second legal risk to consider is around data, and you need to give careful thought to this. We do have a specialist data team who are on hand who do have any specific data queries. But ultimately, you need to be aware that the testing results will be special category data, and you'll be holding a lot of that if you're testing your workforce. So you'll need to carry out a data privacy impact assessment. Whilst you may be able to rely on health and safety obligations to be processing this data, you need to be transparent with your workforce about why you consider it to be necessary and update your privacy notice accordingly. Unlike vaccinations, which like I said, I'll come on to discuss, there are possibly risks of a discrimination claim, but we think this is much, much lower. There are few, if any, valid religious objections or medical conditions, for example, that will prevent somebody from getting tested. Another question that we're getting asked is whether we can insist on employees taking a PCR test if they have symptoms. You can't book the test for them, but you obviously cannot allow anybody into the office if they have symptoms. If somebody starts to develop symptoms, they should be immediately sent home and told to book a test. They then shouldn't be allowed back in until they've complied with all the guidelines and, for example, if you think necessary, having shown you a negative test result and complied with all their isolation requirements. Can you take electronic temperature readings at the entry point? Yes, provided again that it's considered necessary and proportionate. A high temperature is obviously a symptom of COVID, and you'll also need to consider similar data issues to what I've just touched on. So, for example, you'll need to consider whether you record data that's not very proportionate, or are you just going to turn people away, for example, instead of actually recording that they've got a high temperature. Another thing to consider is whether you could get employees to carry out their temperature readings at home. This is possibly less invasive and arguably more proportionate. If we could just move on to vaccinations, the take-up in the UK has been really high. The current estimate is that all over 18s will have had a first dose and 2/3 of adults will have had a second dose by the 19th of July. And on this slide, we've set out some guidance for you guys to have a look through after the session, which sets out quite a bit more detail on various guidance for employers, as well as an FAQ article from us, which covers a lot more FAQs than we have time to touch on today. So moving on to a more controversial question as to whether you can mandate the vaccine. Most of our clients aren't considering this type of policy, but it is really widely discussed, and it's difficult for us at the moment to get through a training session without mentioning it. I literally just heard on the radio that Cathay Pacific are making vaccines mandatory or their staff risk being dismissed. So they're saying that all staff must be fully vaccinated with both doses by the 31st of August. Their reasoning is largely rooted in health and safety, as well as difficulties that they're having managing rotors where only some staff are vaccinated. And I can totally see that their business would be particularly affected because they have to manage the various quarantine requirements if staff aren't vaccinated, and it's looking like quarantine could be linked to your vaccine status. Ultimately, this sort of mandatory vaccine scheme has never been tested, but because take-up in the UK has been so high, it's likely this isn't going to be an issue for most businesses. If you are considering mandatory vaccinations, this certainly shouldn't be a blanket requirement, and you will need to be mindful of exceptions. Our view is that the circumstances that this sort of scheme would be considered reasonable is more limited than mandatory testing. There are two legal risks, similar to what I've mentioned before with testing. So again, if you discipline or dismiss anybody who refuses to be vaccinated, you see where there's a risk. If you want to demonstrate that vaccination is a reasonable policy, you'll need to demonstrate that having a vaccine is the most reasonably practical way of mitigating the risk of COVID-19. Having carried out a risk assessment, you could then possibly be dismissed for health and safety breach if people aren't complying with this policy. So the healthcare industry are probably the most likely to be able to establish this type of reasoning. The government have actually announced that from October, vaccination will be compulsory for those working in Care Quality Commission registered care homes in England, unless people are medically exempt. The government have also confirmed that there will be consultations regarding other NHS workers and carers, but there are no other proposals at this stage. Also, possibly International businesses have a mandatory vaccination scheme, and they might be more likely to be able to justify it, particularly if travelling abroad is part of somebody's job requirements. And that could include analysis of different mandatory schemes for everybody. If there are a particular group of workers who are going to be travelling a lot, it may be more reasonable to introduce this sort of scheme. Of course, when considering this type of scheme, you should also consider whether there are any lesser sanctions, particularly if you were going to dismiss somebody. So considering, for example, redeployment to another role or keeping the employee working from home. There's limited evidence on whether the jab will help. You need to be alive rather than if you already have. The second risk is around discrimination cases. As I said before, we do think that it's reasonable to make exceptions for medical reasons, belief, religious beliefs or other beliefs, and possibly if pregnant. You'll need to make sure that those policies are documented in any policy and be alive to any possible indirect discrimination claims. For example, there's recent research that could result in an indirect discrimination claim. We think the probability of such a claim is low, but it's obviously something that people need to be aware of. There is, of course, obviously the data issues as well that we've just discussed, and making sure that you're being careful with how you're processing this data. If you are, my final point really on mandatory vaccination is that this is going to be much easier to introduce to new recruits rather than your existing staff, because whilst there's still a discrimination risk, there's no unfair dismissal risks because they're not your employees yet. So moving on to looking at what's the alternative to mandatory vaccinations, you can strongly encourage your employees to have the vaccine, and arguably you should. It will reduce workplace risk and help manage workplace health and safety. So we think that that is a sensible step. In terms of other steps you can take, we are aware that some of our clients are addressing misinformation, particularly where they have a younger workforce who are getting a lot of their data from social media. But we know this is an issue. They've started circulating some genuine sources of information to make sure their staff are well informed. We've also been asked about incentives, although I would say that this is now mostly from international businesses, particularly because take-up of the vaccine is so high in the UK. So we're not really expecting this to be such a significant issue in the UK. Lots of international companies are doing things like they're running team competitions and they're providing vouchers. And they, of course, if you are going to provide incentives, you need to be alive to the exemptions that we just talked about, for example, around belief or pregnancy. And you'd also need to be alert to the various timings if, for example, people haven't been offered their second dose yet. In the UK, the most common incentive we see by far is people being allowed paid time off to go to the appointment, and the vast majority of our clients will be flexible with this. When going ahead then to look at vaccination information, again, one of the common questions we're getting is whether you can require employees to confirm their vaccination status. And this will be particularly pertinent if you have got a mandatory vaccination scheme in place. You probably can require them, but it will depend on why you want this information. It needs to be an actual reason that is rooted in health and safety. For example, we don't think it will be sufficient to say a hotel staff to say they just want to be able to tell people that all their staff are vaccinated to boost customer confidence. We don't think that will be enough of a reason. But again, you need to carry out a data impact privacy assessment, and you need to be able to keep that information secure and give some careful thought as to how long you will keep it for. It's the required on the back of these sorts of issues. Perhaps the most common question that I've been asked recently is whether you need some sort of testing and vaccination holiday. We're seeing these more and more, and I think there are very good reasons to have one. They can deal with things like the time off, whether they're going to be paid for time off to go to a vaccination appointment. It can ensure that you're being transparent with your workforce about all considerations that you've got in place, as well as the measures that you're taking. And it can also provide a really important reminder about the fact that we're talking about special category data here, and to help ensure that this just isn't a general topic of discussion between your employees as to whether they've had the vaccine or not, and if not, why not. The HR professionals, I'm sure you're all very keen to limit those sorts of discussions, which we know can get heated very, very quick. Sorts of considerations. But ultimately, a policy is going to be crucial. So that was it from me. I'm now going to pass over to Lisa, who's going to deal with employees who refuse to return.
Thanks, Charlotte. So yeah, I'm looking at employees who are refusing or are very reticent to return to work, and that can be for a number of reasons. So as that first slide sets that, so this is looking at disabled employees in particular. So you owe a duty of care anyway towards your vulnerable employees, and the government guidance has said that this can involve taking extra care. So first things first, it's worth thinking about whether an employee is disabled or may have a disability, and many of the vulnerable employees may well qualify as disabled for the purposes of the Equality Act. So thinking about working from home, that could well be a potential reasonable adjustment, although we don't believe this would necessarily extend to a right to stay at home on full pay if they can't work from home. Bear in mind that it's unlawful to operate provisions, criteria or practices of the PCP that you've heard of before, which would put disabled employees at a disadvantage compared with people who are not disabled, unless, of course, that is justified. That requiring all employees to return could be indirectly discriminatory to disabled people. So think about, are they able to continue to work from home for now? Is there anyone else that can cover that work for you? Just having all of those thought process just to kind of flush out the fact that you've considered all the options. Some companies are providing incentives for people to return to work. So similarly to what Charlotte just mentioned now in regards to vaccination as well, just be aware that if a disabled person can't avail themselves of that incentive because they don't feel safe to return, then that could be discrimination arising as a consequence of that disability. So again, just make sure that you can really justify that and maybe consider incentives in a different way so that the disabled people that you have on your staff can participate. And finally, just remember that some of your employees may not have a disability themselves, but could have partners or dependents who have a disability. And so if that employee may be really keen to make sure that they are protecting those people by not going into work and increasing that risk. So the Equality Act protects these employees from discrimination by association. So again, we need to make sure that where, and if an employee explains certain circumstances to you, that you're alive to this and you don't treat them any less favourably because of that. Okay, thanks, David. If you can go to the next slide. So pregnant employees are treated differently than other vulnerable people, and they may have a greater claim to being allowed to remain at home on full pay if they're not already on furlough or working from home anyway. So pregnant women with heart disease have been included in the list of clinically extremely vulnerable individuals who must not work. And all of the pregnant women have been included in the list of clinically vulnerable as a precaution and advised to be particularly careful about safe distancing, etc., because the risks remain unclear. Okay, so for those under 28 weeks the guidance says that the employee must have a workplace risk assessment with their employer and the occupational health team, and only continue working if the risk assessment advises it's safe to do so. So you can almost treat it in the same way that you would before. You would generally always check with the risk assessment if you, once you're on notice that somebody is pregnant, and then kind of work accordingly. For those over 28 weeks or with any underlying health conditions, that could put them at a slightly greater risk of severe illness from COVID-19. The employer should ensure that they're able to adhere to guidance on social distancing and any current advice on pregnant women considered. So this may require working flexibly from home or in different capacity, and all employers should consider both how to redeploy these staff and also maximising potential for home working if possible. If adjustments are not possible and you can't find any alternative work, then the guidance still says that the employer should be suspended on paid leave. As the employer needs to assess the specific risk to the pregnant employee, and where these are identified, then do all you can to prevent them or to remove the risk. Again, in the same way that you would in any other risk assessment, just bearing in mind the extra obligations. It may be possible to do this by simply enforcing more self-distancing in work. It's a matter for your own risk assessment and if you're confident that you can provide a safe workplace. Thanks, David. We'll go to the next slide. So employees with no childcare. So things have improved a lot now since we started running these sessions. The schools in England and Wales have opened fully, and say for a few instances where certain school bubbles have to be sent home to self-isolate, many employees will find that their childcare problems that they had at the beginning of the first and second lockdown are much less of an issue now, considering returning to the office. However, things are not completely back to normal. So some employees might rely on after-school clubs, that they might not all be up and running as they were 100% before the COVID pandemic. Some employees might have used to rely on grandparents or other support networks and find that they are not now able to rely on those networks, and particularly kind of given that the summer break is coming up soon. So if an employee can't get access to childcare, then there are other options available to them. If they can't work from home, then they do have the right under the family-friendly legislation to take unpaid parental leave if they have the requisite year's service, 4 weeks leave per child. Equally, they may be able to argue that they need a reasonable amount of time off to care for dependents. Now, ordinarily, we'd say that this is limited to allow the employee to look for alternative provisions, so more of an emergency kind of leave. But we be wary of this at the moment. We anticipate that the employment tribunals and the judges are going to be sympathetic to employees who are genuinely finding it difficult to source other ways of arranging their childcare, so just be aware of that. Thanks, David. Okay, now the last category, so probably the most difficult to deal with, so employees who just don't want to come back. So there is a duty of care that still applies for all employees, of course. Be careful that you haven't missed something out, something like a potential disability or another issue that you may have not been aware of at the beginning. So make sure that you have really good communication with these people, because they may be able to kind of flesh out something that you didn't realise was an issue. You could potentially take disciplinary action against such employees when you're sure that you've taken all reasonable practicable steps to control the risks of transmission within your workplace. There are risks involved, as always, in taking that kind of approach, especially because we don't have very much case law indicating how employment law judges and how ETs are going to approach fairness of that kind of dismissal. Any dismissal could be regarded by an ET as being unfair or disproportionate in the current situation. So any disciplinary action could result in constructive unfair dismissal claims. As things get easier, as more people have been vaccinated, as I think people's attitudes in general are relaxing, then this will probably become a slightly less of a risk, but it's still very much worth bearing in mind. Where an employee can continue to work from home, it makes sense to let them do that until you find out a little bit more about what their concerns are. People who come back to the office, the more people who do that, then the more reassured they're likely to be. If an employee can't work from home, then it's worth being cautious and maybe even offering unpaid leave to people who are not able to come back. If they're not able, ready and willing to work, then they're not entitled to pay. That's the thing to remember. So while seeking to reassure the employee that you're complying with Workspace health and safety guidance, offering support with things like mental health, well-being, encouraging them to continue coming into work. You could potentially also agree to put the employee on furlough. Some employers have agreed furlough requests from what we used to call the worried well. This came up quite a lot at the beginning of the pandemic, especially given uncertainty about risk, transmission, what coronavirus really meant. But we've got a bit more information now about these issues, and we can make workplaces a lot more COVID secure than now that we have that information. However, there's no obligation at the moment to place the employee on furlough. So what's important here is ascertaining the reason that somebody doesn't want to return. We're aware that some people who may have developed anxieties about leaving the house as a result of COVID is something that we have seen some of our clients mention on phone calls, etc. And this isn't likely to go away. So just remember that some employees with anxiety, especially if it's now becomes a long-term issue, could potentially qualify as disabled under the Equality Act. You then need to remember the earlier points about reasonable adjustments, etc. I believe that at the bottom of this slide here, we've got some links to the FAQs on staffing decisions when reopening workplaces. Definitely worth to have a little look. This is something that we've been updating every now and again. And also another link that's useful if you wanted to have a look at it later, about thinking about decisions when you're reopening your offices. It's kind of designed a bit like a flow chart, so you can follow the thing and work out what may be the best approach for you to take as well. Okay, so that's my section done. So David will move the slides. Thanks so much.
Thanks, Lisa. I was just going to talk to everyone a bit about flexible working requests in the sort of context of returning to the office. So you'll probably be aware that there is currently a right to request, a right for employees to request flexible working, and that's for all employees with 26 or more weeks service. There is, of course, some discussion about whether this might become a day one right for employees in the future under the new employment bill, but this obviously remains to be seen following the emission of that bill from the Queen's speech last month. You should remember too that although there is only a statutory right once an employee hits 26 weeks of employment, if you refuse a request from an employee in circumstances where they have a protected characteristic, for example, if they need flexible working because of a religious requirement or otherwise, then refusing it unreasonably could amount to discrimination, and those types of discrimination claims can arise before that 26-week period. So aside from that, there are, of course, statutory grounds for refusing flexible working, which include things like additional cost to the business, the inability to reorganise work, the inability to reorganise work, and the impact on quality of performance of somebody's job. So this will all continue to apply going forward, obviously, and you'll need to give good grounds for any refusals and be able to show that you've given proper consideration to all requests. However, just to think about this in the context of the new normal. So some businesses may find that remote working was a success with a completely remote workforce, but actually that it causes some issues when the offices start to reopen. Examples might include the need to schedule virtual meetings alongside physical meetings, the logistics of managing office space, or the problem of a few employees in the office taking on the burden of sort of mundane physical tasks. This may therefore be easier to manage if employees split their time between home and the office, as opposed to a permanent home working model. Just to talk a bit about what best practice looks like when it comes to flexible working requests then. So consistency of approach is really important practice for employees to adopt. So it's absolutely crucial to have a clear, centralised process for dealing with flexible working requests, as just by allowing individual managers to kind of make their own decisions it's likely to result in a certain level of inconsistency and potential exposure for the business. An employer should always consider flexible working requests in the order they are received, and they should approach them positively. And if approval cannot be granted for a request, then the employer should explore alternatives or compromises that might work instead. That said, while many employers have accepted temporary working arrangements during the pandemic that they might not have been allowed previously, so for example, for employees to work whilst they're also looking after children who are at home, then permanent changes should, looking forward, not be agreed to unless they're properly considered to be sustainable. On the subject of trial periods, so trial periods have never actually formed part of the flexible working legislation, but it's still, of course, open to employers to agree a change on a basis. So although coronavirus home working might itself be regarded as a form of trial period, a more formal arrangement would still be acceptable, especially if the employer wanted to see the impact on the business of that flexible working arrangement after most of its employees have then returned to the office or the workplace generally. If an employer wishes to implement a trial period, then it needs to be specifically on the basis that the arrangement is temporary, as I've said, and not a permanent change. So it's important to be clear on the length of that trial period, when it will be reviewed, and also how success or failure will be determined. So in some cases, the use of a trial period can help the employer show that it was willing to consider a change and provide evidence as to why the arrangement would not actually work in the long term. You should also remember that flexible working covers the place that someone works, the hours that they work, and the times that they work. So even with the general flexibility built in, you may get requests to work, for example, compressed hours or fewer days. Just on the topic of working from home abroad, now, unfortunately, I don't have time to cover this whole topic today. It really is a sort of whole subject in of itself, but we've added to the slides, you'll see, and this will be circulated afterwards, a link to our article on the subject, which explains the potential legal issues and how to avoid the most common traps. I will just say that for anyone who is sort of facing this particular problem at the moment with regard to employees working from home abroad, it's really important to take legal advice on this on a case-by-case basis, as there are a number of potentially significant issues here. Lastly, before I pass back over to Lisa, I'm just going to cover off some of the FAQs from previous sessions that we've run on flexible working requests. Firstly, the question of, can we postpone or extend a trial period until after lockdown so that we can make a proper and fair assessment of how that trial is working out? So our answer is that if the employer and the employee have agreed a particular trial period, then fresh agreement will be needed to vary that. So in this case, the employer should consult with the employee. An extension is likely to be beneficial to the employee, as it would mean the flexible working arrangements being in place for obviously longer, and to therefore have an opportunity to show that that arrangement can work. The question of at what point does it become reasonable for an employer to say, we have too many employees working from home? So, I mean, the answer is that there is really no fixed point at which an employer can say that it's unable to accommodate any further requests. The short answer really is that each request will need to be considered on its merits and in the context of the circumstances at the time. In terms of whether or not managers should be proactively asking their teams if they intend to make a flexible working request, for example, in order to allow the employer to consider those requests in the round, the answer is that there is clear guidance from ACAS that requests should be considered in the order they're received, as I mentioned earlier, and that it's not unfair to do this. So this is likely actually to be helpful to employers, because a downside of inviting all requests by a particular date, for example, and then trying to consider them in the round, is that the employer may only be able to agree some requests and not to others, and then might not be able to identify sort of clear and non-discriminatory reasons why they chose to accept the requests that they did and not to accept the ones that they turned down. The question of whether, so we've had people ask, won't our company culture or our sort of team working environment or employee well-being be impacted by home working in the long run? And the question is, can we take these issues into account in relation to requests that we receive with regard to working from home? So those reasons that I just talked about, they're not statutory permissible reasons for refusing a request. But they do have an impact on some of the statutory reasons and potential justification in the case of an indirect discrimination claim. So an employer considering these issues in the context of remote working requests should assess the likely impact in practice and the impact on the quality and performance, which, as I mentioned earlier, that is a permissible statutory reason for refusing a request. Lastly, then, this question of if we introduce a new hybrid or home office working model for the whole organisation, would everyone need to submit a flexible working request? And the answer is not necessarily. So if the employer wishes to change the contractual place of work or required office hours, then it will need to consult with employees, and any contract amendment would, of course, require consent. So if an employee wanted to have different arrangements from their contractual provisions applying generally, then they would need to make a flexible working request. With that said, I'm now going to hand back over to Lisa, who's going to talk lastly about employment contracts specifically for home workers.
Thanks, David. So Charlotte might well jump in with some of her suggestions as well for this one as well. But employment contracts for home workers, this is something that we've had quite a lot of questions about recently. Some of it is as part of thinking about a hybrid way of working, and some of it is as a way of kind of prolonging and making more permanent what has become quite a norm for a lot of people. And we've been advising a lot on creating new contracts for home workers or something completely new, or just amending what you have already. So maybe that you go for something in the middle as well. It's worth having a think about quite a few things when you're thinking about a permanent shift to home working. So you might want to amend the place of work, but retain a bit of flexibility. So, for example, if you work in a team environment quite a lot, and you're working at home, but you are expected to come in and participate and be part of that team, maybe depending on the role, of course, but thinking about brainstorming and that kind of collaborative work, then it's useful that you can require them to come in for a certain amount of time per week or per month. It may well be that supervision is required, or that person requires supervision themselves. So it's really worth having a think about making it not just exclusive homework, but have some kind of flexibility. You might want to think about things like expenses. So, for example, if somebody's working from home and they're working 10 miles away from work, then they would commute as usual if they were expected to come to the office. However, if they decide to move to Aberdeen to live, and the office is in Swansea, then if you require for them to come into the office once a month, then you need to think about whether that person is required to cover their own expenses of flying or getting a train down, something that could actually become quite regular and quite a significant expense that needs to be covered. So just have consideration of that. Think about conditional agreements, whether you have some kind of way of reviewing how it's all going, and whether you can whether you can change certain parts of that agreement as time progresses, or even as regulations and rules and restrictions are lifted. We need to think about taking steps to remove any disadvantage. So again, the things that we've all been getting quite used to being at home, we've now got technology hopefully that works well, and something that can make sure that everybody works as a group. Just making sure that everybody is connected in the way that they need to. Also think about things like, and you probably have already, because again, this has been going on for a long time, but if it's going to become a permanent shift, or even for new starters, think about practical elements like equipment that they might need at home. Think about whether you might have an allowance for somebody to buy certain office equipment that stays in their home, or allow them to take things from the office. And also the usual checks that you might need to do, things like health and safety. Make sure that the new contracts have a way that you can require them to make sure that they have done a desk assessment of their own, make sure that the place they're working is safe. Things like confidentiality. If they're sharing a house with many other people, are they able to really make confidential calls? Are they locking their computer screen as well to make sure that everything that they have on their screen, any kind of client data or any confidential information, is secure? And same to go with getting rid of removal of any kind of documentation. They need to have shredders, etc. You might want to give a little bit of thought to things like data protection. That will also cover that kind of confidential information element of things as well. David mentioned earlier people who work from abroad. Again, that is, as he said, exactly that. It is a whole session of its own with tax elements and all kinds of things. But really important to make sure that the home working contract, that you're really specific that that home work, that the place of location is the address you have on your records at home, in the office. And if they move home, or if they decide to work from anywhere else, at a second home, or for any other reason, that they let you know where that place would be, and that they are not allowed to do that unless they have your prior permission, just in case it triggers any other strange tax obligations for you, just to make sure. There's a link at the bottom of this page for working from home FAQs. Everything that we've had so far should be covered with that, so have a look at that in your own time. And if you've got any other questions, as Charlotte said earlier, then do let us know, do get in touch with us. We've had one question on the Q&A to ask if a recording will be available on this session, and we will do our best to make sure that there is a recording that's available for you. We'll ask the team at Hayes to help us out to disseminate that, and also to try and make sure that we can send you the slides themselves, because obviously they have the links to these documents and to parts of the web that might be useful for you, just to make you aware that there is a coronavirus hub, COVID hub, on the Lewis Silkin website, which is really useful. So I don't think that there are any other questions that I've missed. Again, if there is anything, please get in touch with the people from Hayes, or get in touch directly. You have our details now. If there are any other questions, then please let us know. You're welcome to pop something into the chat if you like. And our details, thank you, David, they're on that last page of the presentation, so do get in touch if there's anything extra that you need to know. Okay, I don't think there are any other questions, so we may have a bonus 9 minutes. we will get in touch with the ladies from Hayes and make sure that everything is sent out to you. But otherwise, if there's no other questions, something there are, so we can wrap up a little bit earlier, so as an extra cup of tea for everyone. Thank you so much for joining us. We'll let you know when the next session comes out. I'm sure that the people from Hayes will let you know. Thanks so much. Take care, everyone. Bye-bye.